evening and welcome. This is Face the Nation. My name is Sonali Vaniga-Baduge. Our topic of discussion is Rights Protection, National Security and the Prevention of Terrorism Act. Now, it's been over 40 years since the Prevention of Terrorism Act was introduced as a temporary piece of legislation in Sri Lanka. Following the enactment of the PTA, and 40 years after, there have been repeated calls for its repeal on the basis that it is draconian and problematic, both by local actors and international actors. In June 2021, the President appointed a committee to make recommendations to the Cabinet Subcommittee to review the PTA. And accordingly, Cabinet approval was granted and a bill was gazetted last month. So earlier today also, the Court of Appeal ordered the granting of bail to Attorney-at-Law Hejaz Hizbullah, who was arrested and detained for 664 days. Incidentally, the Sri Lankan government delegation is currently in Brussels to meet with the EU over the review process of extension of GSP Plus concessions. Also, we are just days away from the UN Human Rights Council sessions, which are scheduled to begin in Geneva on the 28th of this month. So a few things going on there. Let's first introduce you to our panel of guests this evening. We are joined by Ambika Satkunanathan, human rights lawyer and advocate. We are also joined by Mr. U.R. De Silva, President's Counsel, former President of the Bar Association of Sri Lanka. And finally, Dr. Pakyasoti Sarvanmuthu, Executive Director, Centre for Policy Alternatives. Thank you for being with us on tonight's show. My first question is to Dr. Sarvanmuthu. Releasing a statement, the CPA has said that the amendments to the PTA are grossly inadequate, and you have demanded an immediate moratorium on the use of PTA until an acceptable law can be drafted. Could you outline your reasons for saying so, Doctor?
Well, if one looks at the so-called amendments that have been brought into the Prevention of Terrorism Act, one will realize that they're almost entirely cosmetic. They don't go to the heart of the matter, and they don't stand up to the test of international human rights standards, which is what we want. You know, for the last so many decades, since 1979, when the Temporary Act was passed, there has been a campaign to repeal it. Has the PTA, which was instituted as a temporary piece of legislation, has it actually prevented the egregious acts of terrorism that we've had in this country? No, it hasn't. What it has done is that it has framed the culture of impunity that has become the hallmark of successive governments, including, to a very bad extent, this government. You know, why are these amendments, so-called, coming in at this point? Is it coincidence? Is it correlation? Is it causality? As far as I'm concerned, coincidence has got nothing to do with it. It is either, if one wants to be of a charitable disposition, correlation, and if one wants to be what I believe is truthful, it's causality. It's precisely because of GSP Plus. It is precisely because of the Geneva sessions that are looking at the resolution on Sri Lanka. So, you know, we have been playing this game of trying to kid the international community as well as our domestic constituencies that we are doing something. But we are not. I'm sure Ambika will tell you, go into a chapter and verse in terms of the actual supposed changes that they are making, which don't amount to anything at all. That is why we say repeal and replacement with something that meets international human rights standards. because this is what this country deserves. And, you know, they talk about, the government talks about reconciliation, etc. Can you have a piece of legislation on the statute books which is responsible for depriving people of the best years of their lives, in some cases over a decade, and talk about reconciliation? Today, Hejaz Hizbullah has been released on bail, so his little daughter can actually see him in the flesh. I mean, this is cruel. To put it mildly, it is cruel.
Thank you very much, Dr. Sarun Muthu, for sharing your initial thoughts. I'd like to draw my attention to Ambika Satkunanathan, who is a lawyer, a human rights advocate, and a former human rights commissioner. Ambika, the Human Rights Commission of Sri Lanka has an oversight role in continuously monitoring the conditions of persons in custody. Since this is a pivotal sort of area that we need to touch on, could you take us through some of the experiences that you had when you were working as a human rights commissioner?
Yes. So one of the things that I have noticed, because I have been documenting violations related to the PTA for about, I don't know, about 15 years now, and in different capacities, assisting families of victims, advising the United Nations about the law, documenting the violations. And when I was at the Commission, I had to handle complaints from detained persons and their families. And one thing that I noticed is that, at least in my experience of this, 15 years, the pattern of abusers is quite the same. So if you compare the abusers that someone who was arrested for the Easter Sunday attacks in 2019 went through, and you compare that to what someone 20 years ago who was arrested for LTT-related offenses went through, you would find that they're quite similar. So that shows two things. Firstly, that the law is human rights deficient, and that creates room for a lot of abuse. So even the best democratic governments, you would find that even if you have the best laws, abusers might happen. But in our context, we had, repressive governments, we've had internal armed conflict, so you can imagine the extent of violations. And the second thing is, I think, also the practices that we have here. If you take not just the PTA, but even under the general law, the penal code, now I'm sure Mr. U.R. De Silva would be able to explain further, is that torture is systemic. So we would find, when I was at the Commission, you find people who were arrested for very minor offenses would have been subjected to severe violence. So the use of violence is part of that our criminal justice system and process. Therefore, this allows a lot of violence. So what I saw, for instance, one of the things is that under PTA, when they arrest one person, now also due to technology, they would take the person's phone and they go through it, and they would maybe arrest 30 different people because they were on the person's last call list. Now, these are people who might have been, and I can give you examples of, in one case, a person at the Western Union who changed this man's money. He was doing it as part of his job. Another man who had sold him a motorbicycle because, he had a dealership. But those people were also arrested. They were placed on detention orders. They were held in detention centers for about 6 months and thereafter released because there was absolutely no evidence. My question, should they have been arrested in the first place? Should you not have reasonable suspicion at least to arrest them? No. So our investigating process is also quite lax. The other fact that I encountered personally several times in prisons and also once in a detention center is it's very easy to hide people from the Commission, from visiting magistrates, from the ICRC, very easy. Because I've had experiences of people being hidden, and the only reason we found them is because we went to the same place on consecutive days, several times. Therefore, these are some of the practical ways or the experiences that I have had, which illustrate that the law is human rights deficient, that is, does allow abuse. And also in our because we have many systemic and structural shortcomings, and the use of violence is anyway so common, when you give power and such extraordinary power to state officials and to police, the result is gross abuse of human rights.
You spoke of the rampant use of violence, Ambika, but there are, in our legal system, laws to deal with that. There is a fundamental rights jurisdiction, there are fundamental rights which are enshrined in the Constitution. So what of those?
Of course, I mean, Article 11, protection against torture. But that is something that you will be able to access after you have been tortured, right? So the question is, what happens before to prevent that? And even after a person has been tortured, to access fundamental rights jurisdictions, you must know the law, you must have access to lawyers, you must have financial resources. And many people, for instance, if you go to the prisons and you meet, most of them are very poor and they do not have the knowledge and do not have the access. So the question is, what are the protections we can have to prevent? Now, one of the examples that, I mean, you started your question with that, the Human Rights Commission is supposed to be a monitoring mechanism. That is, according to the Human Rights Commission Act, when a person is arrested under the PTA, they're supposed to inform the Commission within 48 hours of the arrest. Even during our time, we found that that really didn't happen. They would just not inform, and it's only when the family came and complained, we find we've not been informed, then we have to follow up. The other problem we have now is that after the 20th Amendment, the Human Rights Commission cannot be considered legally independent because the President makes direct appointments. Now, this has an impact on the way it functions and also on public trust. Therefore, I would say the mechanisms that we have for protection, they aren't adequate. And whatever exists also is not working effectively, efficiently. So with that, when you have an abusive law, you intersect at that point of intersection is where the gross violations of human rights take place.
Thank you very much. I move my attention now to Mr. U.R. De Silva, President's Counsel. Mr. De Silva, when considering the restriction of rights for terror suspects under the Prevention of Terrorism Act, we also need to take into account the fact that the rule of law needs to be upheld, human rights need to be upheld. So adherence to the rule of law is essentially a prerequisite. Given this, how do you view the clause with regard to confessions in the PTA, as it permits confessions to be made to a police officer of or above the rank of ASP, Assistant Superintendent of Police, to be admissible unless the accused proves the statement was not made voluntarily? Now, just to give some context to our viewers, under the ordinary law of the land, under the evidence ordinance, such confessions are usually inadmissible. Mr. De Silva, what's your take on this?
Thank you giving me this opportunity. In fact, this is where we have to think with the new amendment as well. As our resource persons quite correctly pointed out, whether we are in a position to say that this particular amendment is doing a great service to the human right violation, whether we are going above that or we are going to curtail it or to eradicate it. So what we are going to do is, at the moment, we want to satisfy the Human Rights Commission next month's meeting, or else we want to get some relief from the donor agencies. That is the very reason they have gone into halfway. So as you quite correctly pointed out, the latter part says how they are going to prove the case, even if they are, if the authorities are taking into custody a person and then they are keeping them for 18 months. Now it has been reduced to 12 months. And then the magistrate is entitled to go into the place where the person is detained. And the lawyers also, Hizbullah's case, we saw that lawyers were not allowed to go. And this was argued in Supreme Court, And because of that, they gave permission to lawyers to go and interview the relevant suspect. So that part, of course, they have done to some extent. But the most important part would be that how are they going to prove the case? So in the initial stage, when this particular act is enacted and it was brought to the parliament, they say that in a such situation like terrorism is there, nobody is coming forward to give evidence. So to prove a case, it is important to find out to go away with this evidence ordinance, and then they want to have these confessions coming. But the important factor would be they put the confession as an evidence where if the person is voluntarily giving a confession to ASP or above. So with all experience we have from 1979, I have been there 1983 from 1983, and I had a lot of experience in 1989 cases where a lot of confessions are being challenged, and I must say 90% of the confessions are being rejected. So we were able to prove that those are not voluntary statements. The fact remains that the police are not going to get those confession voluntarily. They put force and they tortured them, and thereafter the suspects are being asked to sign. They extract the confession under normal circumstances, and they type the same thing in the ASP's confession also, and they ask them to sign. That's all. So that has been proved, and with that experience, yet the government is not going to change this particular clause where it says that confessions can be proved against the person. If he is going to say that it is not voluntary, it is the duty of the accused to prove that it is not a voluntary statement. I don't think it is correct, because it is very difficult to prove that. But at the same time, if the confessions are given to a magistrate voluntarily, the magistrate can go into that and give the opportunity to think and reflect, and thereafter he can, if he is ready to give a voluntary statement, the magistrate can record the statement. That can be taken into consideration. But at the moment, they have not changed that particular clause as far as the new amendment is also concerned. So I think they have gone to halfway, and to show the foreign people that we have done something. But my personal view is, if we are going to do something adequate, and then if we are going to show that we are in this particular situation, we are going to adhere to the human rights, the important areas of the human rights, then you have to change the particular section with regard to confession. So at this stage, it is not being done, and it will be continued in this new amendment also. It has been considered earlier also in various occasions, but the authorities couldn't go forward.
Mr. De Silva, yes. Also for the benefit of our viewers, if you could just outline to us, now once an individual has been arrested and detained, at what stage does the medical officer get to see him or her? And is there a competent interpreter during the interrogation? And what about legal representation? If you could just sort of outline these areas.
Yes, thank you. And it is important. Earlier, it was not there. So, as pointed out by our resource persons, they were not allowed. They not allowed to go into the detained places, and then even the human rights people are going, they hide those people. So it's a fact. And then in this particular new amendment, it is clearly stated, once the person is arrested, he should be produced before the JMO, and then it should be produced before the magistrate, and thereafter he will be detained. And it is clearly stated only for 12 months and 3 months again, and then after 3 months likewise, altogether 12 months. So in between, the lawyer can go and see him, and thereafter if there are fundamental right cases to be filed within that period, they can go to Supreme Court. I think it is not proper to have that also, because the poor people as far as Batticaloa, Jaffna and other faraway places, they have to come to Colombo and put these fundamental right cases. If they are ready to do the particular area to and allow the fundamental rights cases to be heard in high courts, of course we can see something can be done. But so far we don't know with the new constitution whether they are going to do those things. But at this stage we see that they are always say you can go to Supreme Court. It is now in Hizbullah's case we saw how long he has been there. Even if he has gone Supreme Court, police have not done their duty. They have not completed their investigation. Ultimately, they have filed the cases to satisfy that they have done something. So by doing that, being a lawyer, and lawyers also supporting him, the Bar Association supported it. But unfortunately, what happened? He has been there for 20 long months. And thereafter only in this particular situation, because of the Court of Appeal, and I must thankful to the justices where they have gone into details in this particular judgment. We must read those this judgment. It's clearly stated what actually happened, what is meant by the Parliament, and what is the practical situation. And then they have considered, in the interest of justice, they should allow the person to go because he has been on remand for 20 long months. So that is how it goes. Lawyer now, according to new amendment, lawyer can have the access, but at the same time, the bail also earlier we have to get permission from the Attorney General, Honorable Attorney General, but I think it is not proper. So they have changed that, and then they have stated that before 1 year period is lapsed, if a person wants to get bail, they can file a bail application in Court of Appeal, and if the indictment is served and the trial is not being taken thereafter, then after 1 year's period, then the High Court is given the opportunity to grant bail. That is also with exceptional circumstances. So those things are there at the moment, and even those things are there. How are we going to do it in practical way? Whether the police are going to adhere to those things, whether the other investigation units are going to adhere to those things and allow the person to be there in custody safely. And then if he has done something wrong, he should be brought before court immediately. And then they have stated day-to-day trial. Whether it is practicable or not is a different matter. But if they are in a position to conclude the investigation part quickly and then produce him before court, it is the best way of helping a person.
Right. Thank you very much. At this juncture, I'd like to mention that we invited several representatives from the government on this show tonight. Foreign Secretary Professor Retired Admiral Jainath Kolumbage is currently overseas. State Minister of Regional Cooperation Tharaka Balasuriya declined subsequently. Minister of Foreign Affairs representatives, there were 2 representatives, however, both we were told are in quarantine. So we will do our best to carry on this discourse in an objective manner, taking into consideration both sides of the debate. Dr. Pakisoti Sarvanmuthu, my next question is to you. One may say that ensuring and enabling national security, especially given Sri Lanka's past, it is imperative that we have pieces of legislation that that enable swift and stern action. And to them, what would you say?
Look, I don't think that the arguments with regard to repealing and replacing the Prevention of Terrorism Act deny or say that this country should not have any legislation dealing with terrorism. What is being said is that there are international standards. There are human rights principles to which states have agreed to. Why can't we frame laws that are in conformity with those general principles? You know, and therefore what we need to do in the Sri Lankan context is repeal and replace. And when we talk about replacement, we need to take to heart the point that there are international human rights standards and that any legislation that comes in place of the current PTA is in conformity with those international standards. You know, the argument that the proponents of a repeal of the PTA are not interested in national security or that they're in some way wanting to imperil the security of this country because they have links with terrorism and all of that, that is sheer buffoonery, and it is totally unacceptable in terms of it's a major smear against whoever they make this case. You know, we are talking here about repeal and replacement.
All right, thank you very much for that very comprehensive response. My next question is to Ambika, but before that I'd like to introduce the rest of our journalist panel. I'm joined by Azra Asan and Shehan Ranatunga. I think Azra, you had a question?
Yes, thank you, Sonali. I'll pose my first question to Dr. Sarvanamuthu. Doctor, just this evening, the Ministry of Foreign Affairs, after growing calls to repeal and replace the Prevention of Terrorism Act and the proposed amendments, the Ministry of Foreign Affairs has issued a statement saying that this is a progressive step. Even after so many years, we have done something to make a change in this draconian Terrorism Act. So can't we consider this as a positive step? Or what is it that you see and the government doesn't see and is failing to recognize?
What I see is scores of young men, mostly, and mostly from ethnic minorities, spending the best years of their lives in jail without any hope of coming out. Now, the government says that it has to be a progressive step. What is this nonsense? Is this a progressive step to come up with legislation, amendments to legislation which don't amount to anything? That's not progressive. This is part and parcel of a campaign to hoodwink the international community and fellow supporters in terms of the domestic constituency that something is actually being done. But that's not the case. You know, this is a major violation of human rights. It's a major violation. It has deprived people of years, of decades of their lives. And what are we talking about? Incremental steps, and those incremental steps happen because GSP Plus is coming up for renewal, or because there's going to be another session of the Human Rights Council? Is this a way a government treats the rule of law? Is this a way a government treats human rights? Frankly, is this a way a government treats its own citizens? Surely not.
Doctor, given the current situation of the country, the government's responsibility is to ensure that the people are taken care of. National security, the well-being, the economic situation, and the current situation is such that government could be taking desperate measures to convince the foreign partners. So we'll have some sort of relief on that aspect as well. So it's more of a balancing act. What is the ideal way, Doctor? I don't understand. What should the government actually do then?
Well, we have gone before the Human Rights Council in Geneva and pledged certain things. We have gone and pledged certain things in agreements with foreign leaders, and indeed in terms of speeches that presidents and prime ministers have made domestically as well. What I say, and indeed what the Human Rights Council said in 2008 when they started looking at Sri Lanka was, please implement the pledges and promises that you have made. If we did that, we wouldn't have resolutions on Sri Lanka. We wouldn't have resolutions on Sri Lanka. And if you're talking about the desperation of a government, I mean, who made this government desperate? Only the other day, the president came in with 6.9 million votes. Only yesterday, as it were, they won a two-thirds majority in parliament. What is the desperation? I don't understand it. It's a desperation, if at all, of their own making. And they can unmake that too. With a two-thirds majority in parliament, with a 6.9 million vote bank, as it were, they can turn around and tell the people, look, yes, we have not done certain things, not fulfilled on certain promises. We have looked at this and we now understand that this is what has got to be done. You need to support us in this. Rather than set up presidential task forces of one land and one law and all of that with racist monks at the head of it. I mean, this is just not on.
Thank you, Dr. Mr. Risula, before we move to Shehan, previously when you were on Face the Nation, you were very confident about the conduct of the government or the manner in which we were moving forward. We spoke about a lot of matters, but in terms of this, it sounds like you're not so confident anymore.
Yes, of course, because as I said, we have the practical knowledge and then experience also. With that practical, I am not going to say the things that are done by the government is completely correct, but they have done something halfway. As I told you, to show to the world that they have done some progressive thing. It is not the issue here. Whether we are in a position, or we are ready to help the people, and police are taking people into custody, and then they say under PTA we are investigating. After several months or years, they say we have no evidence and we are not going to have that PTA and we are considering about normal law. So what is the next step? He has suffered. That person has suffered. Because it is very easy. What is the prohibition that the police are having to person get into custody under PTA? Now they are used to that and they are using it frequently, and nobody is going to say anything against them. So that is why I say we must have strict regulation and strict wordings there in the particular amendment to state that you can't haphazardly take a person into custody and keep him for 18 or now 12 months. To 12 months you can't keep him under. And by the way, they are asking us to go to Supreme Court and challenge the detention. So I think it is not correct. If they are ready to give back to the human rights or fundamental right cases to the High Court, then of course we can say we have the opportunity to go there. Even in this particular scenario also, if the person is on remand for more than after taking into custody, if he is there in 1 year, he has to go to Court of Appeal. Court of Appeal also in Colombo. So why can't they give them to the High Court? The High Court has the power and then they have the appellate power also. In this particular case, Hizbullah's case, the Court of Appeal has done something very great and they have called the They say that we have the jurisdiction to give this person bail. So in this particular case, particular act, it is mandatory requirement is that you have to have the procedure to prove a case. If you are going to stick to the same thing where in general law you can't have the confessions adopted or confession taken into consideration, and they are giving the power to ASP to have the confession done and then prove it. The accused has to prove, as I told you, accused has to prove the case for him to come out, and that is not correct. And I think the government should have that particular section abolished, and then put the magistrate should have the confessions recorded, and thereafter, if the confession is not voluntary, it is up to the court to decide. With all the experience we say that this is what we have to do. Terrorism is there, and this terrorist act is should be there. We are not saying that it should be abolished and forget it. No, what Pakistan Sarmutu also quite correctly said that this particular 1979 Act should be demolished and then thereafter abolished, and then thereafter you have to have a proper mechanism and then have proper clauses into particular Terrorism Act. You can get all experience with various countries and have that into operation. Then only people will say that you have done something.
So, if I understand you correctly, Mr. De Silva, you just now said that the need is for a new act, a brand new act. But doesn't it, perhaps, isn't there concern that we're talking about an act that was passed over 40 years ago? It's taken this long, and there have been amendments and attempts at amendments, and yet here we are today in this place. How long will it take before a new act comes into effect? Can Sri Lanka afford to wait in an environment where there is threats, let's say, of terrorism from various sectors? So can Sri Lanka afford to wait?
Yes, you don't have to wait so long, because if you want to have whether you want to have it or not is the important. With regard to constitution also same. So up to 20th Amendment we were doing something, amending, and thereafter only we have considered that we should have a brand new constitution. Likewise, here also we have to have that proper mechanism to have that particular act done. Otherwise, we are just here and there. We are satisfied to satisfy the other end. We are amending this, and then ultimate result will be zero. So that is why I say it should be done, and you have to go A to Z and see what are the things you should change. And according to the World Human Rights Organization rules and regulations, you can get a lot of examples and lot of details, and thereafter you don't have to have everything from there and have it here, but we can go into these things with regard to detention, bail, and then the confessions if it is necessary. So all these things should be done in a proper way. And then other important area is advisory board. That is also very important, where they have considered in this particular amendment also. Now you can see, you can remember very recently this advisory board came into power again. It was there earlier but not functioning. But here also we have given all the details, the detainees detail, Tamil terrorist suspects are there languishing in remand without the case being heard or without the charge indictment is served. We have given all the details to the authorities, but unfortunately they have not adhered to that. That's why I say whether we are in a actual position, we are in a situation where we want to have this done or not. All people, when they come to power, when they want to come to power, they say we are going to adhere to these things, and we are going to abolish, and we are bringing new laws. But unfortunately, when they come into power, they drag, and they are not doing it, but my personal view is that they don't want to have this. They want to safeguard the present situation by amending here and there and satisfying the foreign countries only.
Ambika, as a follow-up to Shehan's question now, if you actually look at the ground reality, putting everything in paper is easy. You can just say, you know, Mr. De Silva said, you don't have to wait for that long. You can introduce a new law, but we know the situation, the real situation of the country. When a government comes into power, this particular government has only 3 more years to complete, and then their future after that is uncertain. So a government would always try to keep themselves safe within this time period that they are in power. In that situation, how will repealing and replacing the act help the people? Because even if we push this and make sure that this is not proceeded and that we get something else, we'll still have to wait for a longer time, like Shehan pointed out before.
When you say keeping safe, there's, I think, keeping the country safe and the citizens safe and keeping the regime in power safe are very 2 different things.
Well, I'm talking about
and
the ground.
What,
the
in
real
relation
situation.
to anti-terror laws, this is not something peculiar to Sri Lanka. In many other countries in the world, you will see anti-terror laws are also political tools. It's something that the regime uses to show that they are strong, to show that they are tough. And particularly a regime that has a government that has 2/3 majority in parliament and could pass something like the 20th Amendment could surely do this. And it's a myth to say that this law has protected us. Why do I say it's a myth? Because you look at the definition. Is there a definition of terrorism in this law? No, there is not. That is a problem. What does that mean? It means the interpretation can be very broad, it can be political, and it can be used to abuse, which has happened. Secondly, let's look at the offences in the Act. An example, Section 2(1)(a) and 1(b). What does it say? It says that anyone who commits an offence that in the penal code would attract a death sentence, that would constitute an offence under the PTA. What does that mean? It means this offence already exists in the penal code, right? But you're making reference to it here. So what this act actually does have are these abusive provisions where, for instance, you can give a confession to an ASP and it can be admissible in court. You can take a person out of remand after the person has been remanded to another place for inquiry. And we have documented many cases of severe torture when that happens. So things like that. And if you
the Minister of Defence can determine where...
That is 15A and 7 subsection 3. So those are the 2 elements, right? One is even after the person is remanded, they can. So I know of persons who were remanded and then kept in Busa for about 2 or 3 years. And they allege that during that period, they were also subjected to torture. That was, quite a few years ago. So like that, it has abusive provision. So what we are saying, are we saying that it's only by abusing other human beings we can keep ourselves safe? Then I think there is a great moral problem here that we need to look into. And of course, if you look at many of the cases as well, there have been also cases where the confession has been thrown out. So what does that mean? It means you really didn't catch the person or who committed the offense, right? Because if you say this is the person who committed the offense, you file an indictment based mainly on a confession, the confession is thrown out of court, the person is acquitted. So where is the person who committed the offense? So in a sense, you're not actually protecting the country and you're not holding the person who committed the offense accountable. You're just, in a way, it's a facade. So for instance, I'll give you the case. It's a tragic case, and I mentioned it in something I wrote also. Someone who was arrested when he was 27 years old, spent 13 years in prison, indictment based solely on a confession, and he was acquitted, right? Within a year and a half of being acquitted, he dies. So who's going to be held accountable for that? Where are the reparations for that? So let's not hold on to this myth. I think it's like a security blanket, but there is no substance to it if you look. So I think that is the thing. It's like you cannot keep a society safe by making certain populations unsafe. So this is an act that, if we look historically, Tamils and thereafter Muslims and also now increasingly dissenters are being targeted. And so for these communities, this act is like, it's always hanging above them, right? And by making them feel unsafe, or by subjecting someone to torture to obtain a confession, I don't think you can keep people safe. Has our history shown us that we can keep people safe? So I think it's a myth.
What about the 20th Amendment to the Constitution? Has it curtailed the powers of the Human Rights Commission? Because at one point the Human Rights Commission can make unannounced visits and check if the people who are detained are being tortured or not. But the 20th Amendment and the powers were taken away from the Human Rights Commission.
The powers of the Human Rights Commission are the same because they are enshrined in the act that established the Human Rights Commission. What the 20th Amendment has done is that it has made the process of appointment to the commission not independent. Earlier it was through a constitutional council, there was an open process, call for applications, etc., etc. Now the president appoints directly. So that is something that can be viewed as undermining the independence. And also the Global National Alliance on Human Rights Institutions has recommended that the Sri Lanka Human Rights Commission be downgraded from A to B status, mainly for this, the lack of independence, lack of focusing on issues like extrajudicial killings and allegations of extrajudicial killings and torture, and engagement with civil society, etc. The irony is that it was pretty much for these reasons that in 2009 the commission was downgraded, and after we were appointed, we applied and we were upgraded back to A. So that's the status, legally and also internationally, of the Human Rights Commission. So when it lacks independence legally, that raises questions about its independence and whether they will act independently. How much trust will the public place on them? Have they looked into allegations of torture? Have they been vocal about public interest issues? So those are some of the questions to ask.
Thank you very much, Ambika. On that note, we go in for a short commercial break. You're watching Face the Nation. We'll be right back.
COVID-19 සඳහා ආරක්ෂිත පියවර. ජනයා වැඩි වශයෙන් සිටින ස්ථානයන්හි ගැවසීම මගහරින්න. රෝගය ආසාදිත පුද්ගලයන් හමුවීමට නොයන්න. මුහුණ, මුඛය, නාසය සහ ඇස් ඇල්ලීමෙන් වළකින්න. අනවශ්‍ය ගමන් බිමන් යෑමෙන් වළකින්න. මුඛාවරණය ඉදිරිපස ඇල්ලීමෙන් වළකින්න.
A brand new year, a year of hope, a year of aspirations and people looking for inspiration.
Our software engineers, our IT expertise are, not seconding to anyone.
A proper investigation led by the CID. This will be swept under the carpet.
Understanding about the stock market, the fundamentals, the economy, that is very important.
Entire ownership of this reclaimed land as well as the governance of Port City are all under the government of Sri Lanka.
No planet, no people, no business.
Yes.
And this is the simple thing about Biznomics.
Your weekend's most profitable 60 minutes. Biznomics. Saturday and Sunday at 5 p.m.
එළියේ හීනියට වහින වැහි පොද මුළු හිතම හිරිවට්ටල දානවා අප්පච්චි.
ඉස්සර මට හිටියේ එක පුතයි දුවල දෙන්නයි. දැන් පුතු 4 දෙනයි දුවල 4 දෙනෙක් ලැබෙනවා.
මේ උඹට පොඩ්ඩක් පුළුවන් ද මේ ලෝකෙට පොඩ්ඩක් ඇවිල්ලා යන්න.
ඇඩ්වර්ටයිසින් කරන්න නැත්තම් මැරෙද්ද?
ඔය දෙකේම වැඩි වෙනසක් නෑ මල්ලි. ඒක නෙමෙයි. ආවයි හාවි කෝ. මම පුරුදු වෙනවා. සත්තයි.
මම මේ ඔය ළමයින්ගේ හොඳට මේවා කියන්නේ. ඔය ගෑනු ළමයා පන්නගෙන යන වැඩේ නම් හරියන්නේ නැහැ.
සුදු හාමිනේ එකපාරටම වෙනස් වුණේ කොහොමද? මේ තරම් ඉක්මනට මේ වගේ ලොකු වෙනසක්?
Welcome back. This is Face the Nation. Is there a nexus between the Prevention of Terrorism Act and the actual prevention of terrorism? Are the amendments to the PTA only cosmetic in nature? Will national security be negatively impacted by these changes? So these are some of the questions around which we are having this discussion. We're in conversation with Mr. U.R. De Silva, President's Counsel, Dr. Pakisoti Saranamuthu, Ms. Ambika Satkunanathan, Attorney at Law. My first question in this round is to Ambika Satkunanathan. I'd like us to focus our attention on the socio-economic impact on the families of detainees. They won't be able to afford legal fees, unable to afford to visit the detainees, financial difficulty faced due to the family's breadwinner being arrested, therefore being in debt, the marginalization and social stigma that the family undergoes. Ambika, are there procedures in place to deal with these kinds of issues?
No, they're not. The short answer to that is no, they're not. And as you said, these are many of the problems that persons and their persons who are detained under the PTA as well as their families encounter. And there really aren't any mechanisms to deal with it. We do have, less than a handful of civil society organizations that, provide assistance. But let's take the issue of competent legal counsel. Many of them, as you rightfully said, cannot afford legal representation, so the court appoints an attorney for them. Now, when we did the National Study of Prisons and we interviewed persons detained under the PTA, not just persons under the PTA, even persons on death row. The problem is that many of the court-appointed attorneys tend to be, they said, they seemed really young, they were inexperienced, and therefore they did not feel that they were getting competent, effective legal representation because they cannot afford, for instance, a president's counsel. So therefore, that is a core part, right? Right to fair trial also means that you should be able to secure competent legal counsel. And if you can't, then if you want to appeal, let's say you're convicted and you want to appeal, then of course you are given a state-appointed attorney even at Court of Appeal, but not to appeal to the Supreme Court. So many people, even persons on death row, we found who had not appealed to the Supreme Court because they could not afford legal representation. If you look at the prisons and even the persons who are detained under the PTA, the socio-economic status is that they do come from poor, marginalized sections of society, and being detained under this law makes their socio-economic situation worse. So if you're talking about radicalization, right? Radicalization doesn't really happen in prisons. I would say radicalization happens in society due to discrimination, marginalization. And when these people are targeted and you send them to prison, a 17-year-old boy who, this is not made up, this is an actual case, 17-year-old boy who, following the Easter attacks, was arrested because a relative took him off to some place, some camp, that a 2-day thing that the chief perpetrator, Zaran, had. Now, this is a 17-year-old boy, goes with someone else, doesn't know where he's going, doesn't know what it's about. He goes and he finds it all problematic and he comes back. And he doesn't really tell the parents because he's also upset about it. Now, if you arrest that boy, now until then he's not radicalized, right? He just went, he came, he's not radicalized, and if at all, he should be allowed to talk about what he saw and you need to talk him through it. But to arrest that boy and to keep him in detention for 2 years, and the person continues to be in detention, what do you think happens to his psyche? I think that is when they get angry. They feel we did nothing wrong, but still I'm in prison. I've not been able to sit for my A-level. So when he comes out of prison, what do you think his mentality is going to be? He's not going to trust the state. He's not going to trust the government. He's not going to trust the police. He's not going to trust society. So that is exactly how radicalization happens. As I said, you cannot make a society safe by ill-treating its citizens. That really is not the way. And this paranoia, if you want to prevent de-radicalization, I think there is a lot of work that we need to do within society. Incarceration is really not the answer, because I've been to prisons, many prisons in this country, several times, right, to every nook and cranny of those prisons. And I can tell you that spending time in prison is really not going to have a positive impact. There are people who go into prison and let's say they're remanded for some very small thing. I have met 17-year-old boys who have been remanded for a fray, right? And they're there for 3 months because they can't get bail and the parents are very poor. And it's in prisons that they might actually learn things or get involved in things that when they come out, then they will continue to be in that. Some professions that are illegal, connections that can land them into trouble. Now that is what actually happens in real life.
But what's the alternative?
Well, the alternative, I think, is all the problems that no one wants to talk about. It's that the state should not discriminate. You should not have discriminatory policies. You must not target communities. You must, if we have equality enshrined in Article 12 of the Constitution, it must be practiced, which we really do not see. And it's those things that no one wants to tackle. Everyone thinks, draft a new law and it solves everything. Not really. You just have different kinds of problems because you do not want to address the root causes here.
Whose failure is that, Mr. De Silva? Not addressing the root cause? Because we hear that a lot in terms of a lot of aspects in society, economy, international relations.
Now, important factor would be the attitudes. Whether the police, who are the people who are starting to investigate the matter, whether they are in a position to, as Amita quite correctly pointed out, whether they are in a position to analyze, smell the person who is going to arrest is the key person or another new person. So if he is not a normal person, of course he can be arrested and keep them in remand. But they take everybody into custody, and then it is the easiest way of doing is to put PTA, and thereafter they think we can send them to remand prison and we are safe and we have done our duty. That is not correct. And she said correctly that by going to prison, they will come out as criminals. They learn a lot of things. They are inside the prison, and they hate the society and the police also. And then when they come out, they are not in proper state of mind. So that is why I say start with the police. We have to change their attitudes. Merely sending a person to prison is not the answer. Merely taking a person into custody by even not for terrorism. But they say that this might be a terrorism act. That is why we are going to have this. And then they put them into custody and then keep them in remand. And apart from that, even the judges also, we say, when a person is produced before the magistrate, it is up to the magistrate to consider. When the B report is filed, they should go through the B report and see whether there is some sort of evidence. It is in Court of Appeal and Supreme Court, it is clearly stated, you can't just send a person by satisfying the police. You have to go through the B report and see whether there is evidence to remand that person under PTA. If it is not, then the judge is in a position to reject that application, and if he wants to help the police, he can remand under normal law, but not the PTA. So this is what we have to think of. As you asked that question, that's a very important question. Merely because the law is there, even if we brought a new law to this particular situation, we will not get the 100% successful things, because if we are not going to change our attitudes, firstly the magistrate, firstly the police, and then the magistrates also, and the High Court judges also, they should look into this matter in a broader way. Now recently we saw Court of Appeal and the Supreme Court have gone into these matters in a proper way and interpreted in a broader way, and thereafter they have given broad the judgments in the way that we see it is appropriate to the society. And there is another section 11, where it is clearly stated restrictions of movements. So without keeping a person in custody or detention, if a person, if the police doesn't have proper evidence, still they want to investigate the matter, they can ask the magistrate to release that person and then restrict the movements. So it's very easy, and he can be there with their family, with his family, and then if it is needed, they can report and they can observe what is going to happen. This is how it goes. And then if you want to keep that in proper way, this can be applied, and then thereafter, as I told you, advisory board should be there to go into this matter. Otherwise, merely the police is going to send the IB extracts to the Attorney General's Department. They have a lot of cases to attend into, and then they will take a lot of time. Ultimate result would be that person should be there till the all indictment is served. So that we have to have that proper mechanism. Otherwise, we merely because we say that the amendments are there and we have done our duty, it is not done, and it is not the way it should be done.
Mr. De Silva, I'd like to get your opinion on the socio-economic impact, the question which I raised with Ambika previously, about the socio-economic impact on the families of the detainees. And I want a response from you which is geared towards finding or proposing a solution. Now, when we speak about access to competent legal counsel, as a past president of the Bar Association of Sri Lanka, what is the role of the legal community or the legal fraternity headed by the Bar Association of Sri Lanka in enabling and ensuring that families of detainees under the PTA are given competent access to competent legal counsel? There seems to be a disconnect here.
No, in the sense that now if family wants to have a proper lawyer, they don't know what is the case and how difficult is the case. So there should be some sort of voluntary organization. They should discuss with the family as well as the accused and see whether the case is a difficult case or not. If it is so, then even a president counsel should be there to appear on behalf of that particular accused as an assigned counsel.
So currently the Legal Aid Commission of Sri Lanka is there.
Yes,
so are you saying
there.
that is insufficient?
Yeah, now only thing is the Legal Aid Commission has other work also to be attended, and then if they are doing it, it's a good thing. And now they, as far as the bail applications are concerned, they are doing it, not the cases are concerned. Because I think there are various organizations, they go to prisons and they discuss with them, and if they are in a position to find the case is a bit difficult and there should be some senior counsel to be there, then they can come out and inform the bar association, and then thereafter, if they want, they can retain senior lawyer also, not as a person who is coming with it's a monetary value. But if they say that this is a person who needs your help as an assigned person, then he can, even the President Council should appear and do the services. Then only we can see we are helping the people who have been detained unnecessarily and unwantedly, but they will get the relief and they will feel that though we don't have money to retain a senior proper counsel, but even they are coming forward and appear as assigned counsel.
Thank you very much. Shehan?
Dr. Sarvanamuthu, I want to just get your idea on this concept of rehabilitation. This is, how important an area is that to you for Sri Lanka to go forward when you look at our history, where we've come from? Do you think enough has been done when it comes to rehabilitation?
Well, my emphasis would not be on rehabilitation, because rehabilitation involves a process whereby there are certain people who are practicing it on others. And therefore, they are taking the decision that X and Y have to be rehabilitated. And that could be grossly unfair. It could be grossly out of order. My argument is not that rehabilitation should be given the priority in terms of the way people's minds and attitudes and all of that should be changed, but that we have to go for reconciliation in this country. We are a country of different peoples. We have come together in some sort of notion of unity in diversity. The idea that there should be one law, one country, one law, means that the desires of the majority community, which is what, something like 75%, will hold sway. You know, the whole notion of this idea of unity in diversity has been thrown out of the window. My understanding was, for example, that, say, the independence celebrations, just a small thing like that the independence celebrations, apart from what was shown on television, that at the independence celebrations, everything was in Sinhala. Now, there are 2 official languages in this country. Each one should be given their status. You know, so, you know, the thing about rehabilitation is not what I am interested in as such, because I think there is something much more important, and that is reconciliation. Within the framework of reconciliation, one can try rehabilitation in terms of the socio-economic dimensions of a person's life, etc. But it has to be framed in terms of the equality of all the citizens living in this country. You know, there is a famous quotation by an Israeli academic called Magdalit, where he wrote a book called The Decent Society, where he says that society should not have institutions which humiliate citizens, and citizens should not humiliate each other in the public realm. And that's what you call the difference in terms of a civilized society and a decent society. And that, I think, is what we must strive for. And that framework has to be reconciliation. Rehabilitation and all of that can come thereafter. I think people that talk about rehabilitation today are putting this emphasis on economic development because they don't want to talk about the mental trauma that people have been through. They want people to forget. They want the future to be built on collective amnesia. That's never ever going to be possible in any country.
And for how long can a society sustain like that?
I don't know, but I don't think we can stay like this for very long.
Do we not get that part? Is that the problem?
Well, what we don't get is that we seem to have decided that one particular family will provide strong leadership. And that's what's needed. But what you have is someone whose notion of strong leadership is like running a military brigade. And that might well come unstuck. You know, what we have to do is to bring people together. We need political leaders who are strong, yes, but that strength must also integrate empathy and sensitivity towards their needs.
But we did have previous governments, Dr. Sarvanamuthu, and doesn't seem like they've done anything great.
Well,
we can't just simply put the blame on the current regime, can we?
No, I'm not simply putting the blame on the current regime. Every single regime that we've had since independence has their share in the national debacle that we're in. But one hopes that each successive regime learns something from the mistakes of their predecessors and builds upon that learning into a positive, constructive knowledge for the better. And my point to you is that that has not happened. And it must happen, or else this country is going to sink further and further into the abyss.
Dr. Sarvanamuthu, something that I've personally noticed is certain policymakers, and a majority of them, seem to be genuinely unaware or ignorant of the nuances of transitional justice, of the importance of rule of law, or the importance of democracy, reconciliation, peace building, because they don't know any better. I'm not saying that's a good thing. I think that needs to be fixed ASAP. So education can play a significant role, peace education, talking about where we went wrong.
Yeah, absolutely, but that's a long-term plan. We have to teach children what's civics. I mean, when I was in school, we learned civics. We learned about our constitution. I don't think they learn about their constitution. I think the last 20 to 30 years of the politics of this country is not spoken about in schools. There is this absurd requirement that you have to learn history in your mother tongue. What on earth does that mean? Your mother tongue, you know? I mean, so there are absurdities of that nature whereby you're just perpetrating the bigotry that has come from the past. We can't go on like that. It has to change. But as I said, education is a long-term requirement, because quite simply, as far as the sort of question of reconciliation, all of that goes, we segregate kids from the word go. We put them in the Tamil medium, we put them in the Sinhala medium. Then we have a distance qualification. But of course, all schools in the national school system are not the same. How many people have changed their addresses to send their children to Royal College and Visakha Vidyalaya? Corruption, that's where it starts. Can you blame them? Open question. Yeah. So we have a lot of root and branch reform that we have to engage in, most certainly, yeah.
Ms. Sadgurunanan, does debating get a bit tiresome? I feel like around this time of year, year after year, this debate comes around, you have these discussions, there's a lot of discussion, but do you honestly believe that Sri Lanka can truly change? That what you are fighting for can actually happen? Or is Sri Lanka so used to just putting out fires on a daily basis? What's the talk of the town? Let's sort that out right now. And once we forget it and we move past that, it's the next hot topic.
Well, I think debate is something that is very necessary in a society, especially in a democratic society, or discourse, you know, people speaking about these issues. And I don't think we should discuss transitional justice or accountability or disappearance or the PTA only when we are being reviewed for GSP plus privileges or just before the Human Rights Council sessions. That is where the problem is. Not that we debate it during this time, but only the point is we debate it only during this time and most often. And that is where the problem lies, because these issues are seen as issues that affect only a particular population. So it's like, right now only Tamils and Muslims are mostly pretty much detained under the PTA. So that's an issue for that community. Or the families that disappeared, there were Sinhalese who were disappeared during the JVP era, but they're not, particularly active because it's been so long. Their families, the parents have passed away. The other members of the family are not so interested in pursuing justice claims, and therefore the issue of enforced disappearance is like, okay, it only affects the Tamils, so the others don't have to care about it. That is part of the problem, that we think certain problems affect only certain parts of the population. But that's not true, because it's the state that is perpetrating the violence or abusing human rights. And if it's abusing a particular population now, it can also abuse another population later, right? I mean, there are other marginalized populations like LGBTIQ persons who are also persecuted. Now that, once again, there isn't much discourse on that. Now, for a person who is an LGBTIQ person from that community, they would look at a state as the problem. Yes, there are laws, there are practices, police, violence, discrimination. So I think debate is important, but what we must do is work to ensure that people, citizens, actually see these problems as something that is common and something that is showing us that the problem lies with the state. The state needs to be reformed. State structures are discriminatory and abusive. And of course, as you said, we Sri Lankans have very short memories. So yes, this is an issue now, but we forget about it and we move on. So that is also part of the problem, I think.
Thank you, Ms. Satkurunathan. Dr. Saramuthu, do you think there's too much emphasis on the state in Sri Lanka? As in, we've given too much power to the state. There are some parts of the world where, when there's an issue, they themselves go and, call at the hotline and say, look, there's something wrong with this product. But in Sri Lanka, we don't do that. We just ignore it. And
yes, I think we have given too much power to the state. But to change that, we have to have the state to agree to change it. Insofar as there are 225 members of parliament who make the laws of this country. And ultimately, they're the ones who have to be persuaded to make the change. They can come up with a 20th Amendment overnight, like they did. But they will turn around and say, repealing the PTA has got to be a long, drawn-out procedure, because the country will go to rack and ruin if they don't take their time over it. So, it's about convincing the politicians about what is important to them.
But we elected them, Doctor.
Pardon?
The people elected them.
No, exactly. They come from us. They don't fall from the skies or crawl out from under a stone. They are us. And so, therefore, we have to decide, or at least those of us who believe that this is so, we have to decide, we have to try to ensure that we can change them. By using the media, by having meetings, by having demonstrations, by doing publications, etc., rousing them to recognize what their rights are, rather than pick up a gun and do it that way, because we know what violence has done to our country in the south and in the north and east. It's not going to happen overnight, but at least I think we must try to get some hope and confidence that we are inching our way towards it, rather than retreating backwards at a major pace.
Dr. Sarvanmuthu, I'd really like your perspective on this next question, which is a little off topic, but also on topic. When we speak about our policymakers, the 225 parliamentarians or people's representatives that represent our best interests in Parliament, and enact our laws. Recently, I watched a video clip where a member of parliament was being so nasty and saying the most derogatory things about another MP. And in my mind, I was thinking, what happened to you to make you this cruel and unconscionable? So I feel like if we can, as a people, as a society, make our parliamentarians a little more empathetic, a little more kind, and a little more aware and knowledgeable about the sadness that we feel when injustice is being done, I feel like we can look forward to a better tomorrow. What are your thoughts?
Join the political party and ensure that you have a say in the choice of candidates. That's the major problem. There is no intra-party democracy in this country. All political parties are run like fiefdoms. If you're really interested in bettering the caliber of the members of parliament, then you have to do something about it. Join that political party and make sure that either you or someone else becomes the candidate and doesn't behave in such a fashion. Quite frankly, I can't think of anything else to be done.
Ambika, any thoughts on this?
Elected representatives.
Yeah, how do we make them kinder?
Well, I think then I go back to my original point, which is I think we need to make our society kinder. We need to make our society more empathetic, and that starts at the home, it starts at the school. It's, it's at every stage, and it's the politicians.
Sounds like a pyramid scheme, actually.
Well, yeah, I think maybe it's because people think like that, they also feel like, well, we can't do it, we won't do it. So the easier way is, let's just make a few more laws, or let's just get this one miraculous person. The fact is, not one miraculous person cannot bring about change, especially not in today's world. It's a very different world. People quote Lee Kuan Yew and all that. Different times, different world. So I think what you need are systems, processes, institutions that work. You need devolution of power. So I don't think you can find one person who's going to fix everything, because the problems are structural, systemic, and people are part of the structures, people are part of the problem. How are you going to magically solve it?
Dr. De Silva, one question for you. Recently, Professor G.L. Pierce said, not many people are aware of the fact that the title of the PTA holds the word temporary in it. And that's precisely what it's called. It's called the Prevention of Terrorism Temporary Provisions Act. Is there an opportunity, you think, now for this government to truly make a change? Is this the time, is it an opportune moment for members of the public, such as yourself, to convince the government to take this opportunity to
as you said, the temporary, we have to change temporary and say permanent, because otherwise no purpose of having temporary. This is what we say. We must have Anti-Terrorism Act. That's a fact. So whether this Prevention of Terrorism Act, now earlier in 2017, the President has pledged to have a separate act, and they brought Counter-Terrorism Act. But unfortunately, somewhere in May, it was put into Parliament, not gone. So that is also not, they have not used temporary. They have stated Counter-Terrorism Act. So what I am saying is not the name. Whether we are in a position to go into every detail and have a proper act for this particular terrorism. And we never say that we should abolish it completely. We must have that. In all the countries, we see that terrorism is there, and they have their particular acts in various names. But unfortunately, we have used the name temporary. So the minister has stated that this word is temporary, that is for temporary use. But they are using it forever. So they are going to safeguard themselves by using this particular act. So that is why we say now this particular government, earlier 2017 we couldn't do it, this particular government has done part of that and halfway they have done it. Now what is the next step? They have to go into this and have these laws they are in the curricula. How long will they take? We don't know. We have to start from that point. And then if we are going to think by keeping a person in remand is the solution, that is not that. So we have to think loud, out of box, then only we can see something can be happen. So people should get together and do something, and then if they want to do it immediately and properly, we have a lot of educated people, eminent lawyers are there. So they will give their fullest cooperation. But the government, whether they are going to ask their help or not is the issue here. Whether some people are going to go there and then do the needful, and then subsequently we feel that it is not properly done. So what is the issue here is we have to do the whole thing, but at the same time, if we think that the keeping a person in remand, even under normal circumstances or under PTA, keeping a person in remand is not the issue, is not the solution. We have to do the investigation part quickly, and if we are not in a position to properly done quickly, then you can release that person under section 11 and ask the person to be there with their family. Then they don't want to say anything, bail out will not arise, restriction of movements is there. It is a very proper way, a practical way of doing things. And by the time, if they are being called to the court, they can come and then face for the trial. So that is how we should do. If the government is going to adhere to these things, we will see a proper mechanism will be there. And as we all say, we want this to happen, and it won't take long. If they want to take proper action, they should consult the necessary eminent people and ask them to do that immediately.
Thank you very much, Mr. De Silva, for your thoughts. We're going for a final commercial break. We'll be right back. You're watching Face the Nation.
COVID-19 සඳහා ආරක්ෂිත පියවර. නිතරම හොඳින් සබන් යොදා දෑත් සෝදන්න. සබන් හෝ විසබීජනාශක මධ්‍යසාරයක් භාවිතා කර දෑත් පිරිසිදු කරන්න. සැම විටම අන් අය සමග මීටරයක දුරස්ථභාවයක් පවත්වා ගන්න. හැකි සෑම විටම නිවසේ රැඳී සිටින්න. නිරතුරුවම නිවැරදිව මුඛාවරණ පළඳින්න.
තනිව යන්න බෑයි කියන කාරණේද අධ්‍යාපනයේදී
මම කියන්නේ ප්‍රධාන වශයෙන් සිදු වෙන දේ.
අපිට රුසියානු සපත්තුව මේ ලංකාවට දාන්න බෑ, ඒක ලොකුයි. චීන සපත්තුව සීන සමාජවාදී ඒකත් හරියන්නේ නැහැ. ඒක මේ කකුලට පොඩි. අපි අපේම සපත්තුව මහ ගන්න ඕනේ කියලා.
එක්සත් ජාතීන්ගේ මානව හිමිකම් කවුන්සිලය කියලා කියන්නේ මානව හිමිකම් පිළිබඳව ලෝක පාර්ලිමේන්තුව.
අපි පරිසරය ගැන දෙකක් තිබුණා.
මම ඉස්කෝලේ යන කාලෙත් මේක තුන්වන ලෝකේ රටක්. දැන් මම මැරෙන්න යන කාලෙදි තුන්වන ලෝකේ රටක්.
ආණ්ඩුව රූපාන්තරණය වෙනවා රාජ්‍ය බවට.
එත දෙකේ එත පහේදී තමයි මේ වතු ඔක්කොම නැෂනලයිස් කරේ.
එහෙමයි ධර්මශ්‍රී, රට ගැන විතරක් නෙමෙයි මම ගැනත් මම බය වෙලා ඉන්නේ.
අපනයන කවුද කරන්නේ? කවුද විශ්වවිද්‍යාලයට ගියද? කවුද අපේ ව්‍යාපාර කරන්නේ? විශ්වවිද්‍යාලයට ගියද?
Welcome back to the show. We're discussing the Prevention of Terrorism Act, its newly proposed amendments, and how we can best go about preserving national security, territorial integrity of the Republic, whilst ensuring the safety of communities, members of the public, and enabling the suppression of ethnic and religious extremism. So does the PTA, is the PTA able to do this, or is it, as most say, draconian, and must it be repealed and replaced? These are the areas, some of the areas that we discussed on tonight's show. My final question to Mr. U.R. De Silva, President's Counsel, former President of the Bar Association of Sri Lanka, is taking into consideration our discourse over the past 1.5 hours, Mr. De Silva, the legal fraternity has a pivotal role to play in ensuring that people who are detained under the provisions of the current PTA, their rights are not violated, mainly because most of the people who are arrested and detained under the PTA aren't aware of their rights under the law. So how do you propose for a system to be conceptualized and implemented with the concurrence of the Bar Association of Sri Lanka to go about this?
Bar Association of Sri Lanka, Legal Aid Commission and the Minister of Justice, they should get together and see whether they can have a mechanism to educate the people who are there in remand custody or detained, and then they will be given the opportunity to find out their rights. Now, according to new amendments, they have some sort of rights. Earlier, the lawyers are not given the opportunity to go and meet them. So here, of course, as I told you, the Bar Association, the Legal Aid Commission and the Minister of Justice, they can appoint committees to go into various places, and then those lawyers can help the people to come out to know these the new amendments and their rights also. So by coming to know that, they will feel that they are not ignored. So then they can fearlessly come before court, and then they can see what is happening in courthouses. And most of the cases that they are at the moment, we see the people are languishing in remand for 10 or to 15 years. Their cases are not being heard. But we have given all the statistics to the Attorney General's Department as well as the Ministry also, and what they are going to do, we are watching. So if they are ready to come out, those what is going to do with their cases, and then if they are in a position to say that we are not in a position to continue with those cases, or we will do it immediately. According to new amendment, day-to-day trials are being there. So if the person is ready to go before courthouse, the court is going to hear the cases day-to-day basis. So that is a good movement. If there is any problem, then it is clearly stated, then the court can state the relevant areas why they are postponing, and then thereafter it can be postponed. So then that is the correct way of analyzing the cases without keeping a person in remand indefinitely. So even if he is being in remand for 1 year or 1 year period, it is the duty of the this Bar Association or to the Ministry of our ministry to find out why they are being kept on remand. So Legal Aid Commission can come forward and do their best for the people to get bail applications done, and if they want to retain senior lawyers also. They can ask the senior lawyers to come forward. This is that way that we can help the people to know their rights, and then if they want to get bail and if they want to appear on behalf of them, we can do so. If we are going to do those things, and I think we will be helping as the legal fraternity, we are in a position to help them in a better way.
Thank you very much, Mr. U.R. De Silva, for your final thoughts. Ambika Satkunanathan, human rights lawyer, advocate, and a former Commissioner of the Human Rights Commission of Sri Lanka. Ambika, Sri Lanka is a party to several key international human rights conventions. Human rights defenders point out that the Prevention of Terrorism Act is not consonant with these international human rights conventions, and it is also not consonant with international best practices. Your thoughts?
Well, I would say they are correct, and I think if we look at the proposed amendments, they do not address the core problems. That is administrative detention, that is where you're not produced before a magistrate, you're not produced before a judicial officer, but the executive can keep you in detention. That's what's called administrative detention. Still, it can be done for 12 months. They've reduced it from 18 to 12, but international best practices and standards say, for instance, the UN Committee Against Torture has said that administrative detention in any form must be eliminated. So that still exists. The provision that enables a confession given to an ASP and above as evidence, that still exists. Section 7, subsection 3 and section 15A, which allow a person to be taken out of judicial custody and kept at another place or taken out for investigation, which is when the torture, really bad torture happens, those provisions are still there. Even where bail is concerned, it says that, you know, if the trial has not begun after 12 months after being arrested, or if the indictment has been filed and trial has not begun for 12 months, then you can be given bail. But it still allows, section 15(2) is still there, which means that during trial, if they indict and the trial starts, the magistrate, the court can still remand you, so you can be in detention. It says it gives new rights, but it doesn't, because you could also still earlier, before even now, you can file fundamental rights petitions challenging the detention. The Human Rights Commission has been, you would note, been mentioned in the amendments, but those rights also exist in the Human Rights Commission Act. Then, of course, the magistrate's visits, at least minimum once a month. But as I said, it is very easy to hide people. The amendments say that the magistrate has to provide, ensure provision of medical assistance if they find a person has been tortured, but it doesn't make it mandatory for the magistrate to refer that to the IGP for investigation. Also, there are no provisions to transfer a person from that place to another place to protect the person from further torture, which means that even if people are tortured, they are not likely to tell the magistrate because they fear for reprisals. So when you look at these elements and you look at the proposed amendments, I would say that they barely address even 2% of what the actual problem is, and I would call it an eyewash.
All right, thank you very much, Ambika Satkunanathan. My final question is to Dr. Pakiasothy Savanmuthu, Executive Director, Center for Policy Alternatives. To quote Attorney at Law Ermiza Teagle, human security must not suffer in the name of national security. Given the PTA and its provisions and the amendments which have been proposed, which are now under consideration, whilst taking that and juxtaposing it with the upholding of the rule of law, national security, what must be the balance that we draw?
Well, the argument that human security should not be in any way be cast aside in favor of national security. I mean, I think that is a more complicated and complex question than it seems at first thought. But I think underlying that is the rationale that at the end of the day, the country is made up of individual human beings, and those individual human beings have certain rights that accrue to them by virtue of the fact that they are human beings. And it must be very, very exceptional circumstances, and the law must be very clear and as precise as possible as to what these circumstances are in which those rights can be derogated from. Yeah? So I think the argument at the end of the day is that human security and national security are not really different if you get the balance right. That at the end of the day, because human beings are part of the nation, and indeed, beyond that, part of the world, human security, therefore, makes up for the collectivity of national security. And if you get that right, you would hopefully have a happy, prosperous, peaceful population which will be able to enjoy its democratic rights. But I do want to say this, though, that it is a fairly complex and complicated process. It's not an easy one by which you arrive at that particular reconciliation.
What is the way forward?
The way forward in terms of
the PTA and its amendment?
Well, I mean, the way forward is, I think, quite simply repeal and replacement. And you go out and explain to your constituency and to the country at large as to why you're doing it and as to why it is in the interests of everyone in this country to do so. We've had major campaigns where governments have launched major campaigns. You know, in 2016, I was the secretary of a consultative task force on reconciliation mechanisms, and the first thing we did was to tell the government, look, you need to go out and explain what you mean by transitional justice. The President and the Prime Minister. So they said, write us a speech. We wrote the speech.
Okay.
The speech was never made. So, if the politicians have these as priorities, there is no question of talking about insurmountable mountains and hurdles that have to be surpassed. It's not the case. They can do it, and it is up to us to make sure that they will.
Thank you very much, Dr. Pakiasothy Sarvanmuthu. Well, with that, we wrap up this edition of Face the Nation. Thank you for joining in this discourse. I'd also like to thank Azra Asan and Shehan Ranatunga for asking the right questions, and our fantastic panel of guests, Ms. Ambika Satkunanathan, human rights lawyer, Mr. U.R. De Silva, President's Counsel, former President of the Bar Association of Sri Lanka, and Dr. Pakiasothy Sarvanmuthu, Executive Director, Center for Policy Alternatives. We discussed a lot of areas on the Prevention of Terrorism Act, its amendment, calls for its repeal and replacement. At the beginning of the show, I did mention that we had invited several government representatives. However, due to various reasons, they declined. Thank you once again for watching Face the Nation. Good night.
TV1 රැස් විහිදෙන ජීවිතේ